While the media obsessed over political drama and celebrity gossip, something truly historic happened in Washington, D.C., and almost no one noticed. In a stunning 9-0 decision, the U.S. Supreme Court issued a ruling that didn't even mention the words gun control. Yet legal experts are calling it the biggest blow to state assault weapon bans in American history. From California to New York, Illinois to Connecticut, anti-gun laws just got a serious reality check, and the mainstream media has gone silent, but not here.
Welcome to Firearms Law Advisor,
where your rights come first and the truth doesn't get buried. Chapter 1. The Case That Started It All. In 2021, the Mexican government filed a bold and controversial lawsuit against some of the biggest names in the U.S. firearms industry: Smith & Wesson, Glock, Colt, Ruger, and others. Mexico's argument? These companies were knowingly fueling the cartel violence, devastating their country by allowing firearms to be trafficked across the border. They didn't claim the companies broke the law directly. Instead, they tried to hold them responsible for crimes committed by third parties, the smugglers, the dealers, and ultimately the cartels who use these guns in violent crimes. The price tag? Over $10 billion in damages. It was a legal Hail Mary, an attempt to use American courts to make U.S. gun makers pay for violence in another country. The case moved through the lower courts, drawing global media attention. Initially, a district court dismissed it, citing a 2005 federal law called the Protection of Lawful Commerce in Arms Act, PLCAA. What's PLCAA? It's a law passed by Congress to protect gun manufacturers and sellers from being sued when their products are misused by others, as long as the sale itself was legal. In other words, you can't sue Ford because someone drove their car into a crowd. And under PLCAA, you can't sue a gun manufacturer because someone used their product in a crime. But Mexico appealed, and eventually the case reached the highest court in the land. And then in June 2025, in a rare moment of complete agreement, the court issued a 9-0 unanimous ruling in favor of the gun manufacturers. 9 justices, liberal and conservative, stood together and said, "No. Foreign governments cannot use our courts to attack American businesses for crimes committed by others in their own country." But the story doesn't end there, because buried inside that decision was a sentence that changed everything. Chapter 2. The sentence that changed everything. In the Supreme Court's 9-0 decision, there was a sentence, just one, that now echoes louder than the rest of the 25-page opinion. Although the ruling focused on whether Mexico could sue U.S. gun manufacturers, tucked inside the text was this powerful line, written not by Justice Thomas, as widely misattributed, but by Justice Elena Kagan, who authored the unanimous opinion. Firearms like the AR-15 are widely legal and commonly owned by law-abiding citizens for lawful purposes. That's not just an observation, that's a binding factual finding issued by the full weight of the United States Supreme Court about the AR-15, the firearm most often targeted by assault weapon bans. Why does common use matter? Because under Heller and Bruin, the court ruled that the Second Amendment protects the possession and use of weapons that are in common use for lawful purposes by responsible citizens. In short, the government cannot ban a type of weapon just because it looks scary or because it's used by criminals. If that same weapon is also commonly owned and used by millions of ordinary Americans for lawful purposes like self-defense, home protection, hunting, or sporting. And here's the kicker. According to the National Shooting Sports Foundation, as of 2025, there are more than 24.4 million AR-style rifles in civilian hands in the United States, making them more common than Ford F-150s or most full-size trucks on the road. So when Justice Kagan wrote that sentence, she wasn't being poetic. She was planting a constitutional landmine under every single state-level assault weapon ban in the country. What does this mean in practice? It means that legal teams across the country can now walk into a courtroom, point to the Supreme Court ruling, and say, "Your Honor, the Supreme Court has already told us these rifles are widely legal and commonly owned. That makes them protected under the Second Amendment. Case closed. It's not an overstatement to say this one sentence, quietly buried in a ruling about cartel violence, may be the death blow to every assault weapon ban in America. Chapter 3. Why this sentence destroys assault weapon bans. To understand the power of that one sentence, we need to look at two critical Supreme Court decisions: District of Columbia versus Heller, 2008, and New York State Rifle and Pistol Association versus Bruin. In both cases, the court laid down a simple but powerful rule. The government cannot ban firearms that are in common use by law-abiding citizens for lawful purposes. This legal test is the backbone of modern Second Amendment protection. It doesn't matter how scary a firearm looks or what politicians claim. It comes down to use and ownership. Now, let's look at the numbers. According to the National Shooting Sports Foundation, more than 24.4 million AR-style rifles are owned by civilians in the U.S. as of 2025. That's more than most car models on the road. These rifles are used for home defense, competition shooting, hunting, and recreational purposes, clearly lawful activities. So when the Supreme Court stated in its ruling that AR-15s are widely legal and commonly owned, it effectively sealed their constitutional protection. Gun rights attorneys now have the clearest ammunition yet. If the AR-15 is common and lawful, it cannot be banned. Period. That's why this sentence is being cited in legal challenges across the country, and it's already reshaping the future of assault weapon laws. Chapter 4. The legal dominoes are already falling. The ripple effect of the Supreme Court's ruling is already being felt, especially in California, ground zero for some of the strictest gun laws in the country. One of the most high-profile challenges is Miller versus Bonta, where federal judge Roger Benitez struck down California's Assault Weapons Control Act, calling it unconstitutional. His reasoning? The state can't ban firearms that are in common use by law-abiding citizens. Sound familiar? Now, with the Supreme Court's 9-0 ruling stating outright that AR-15s are widely legal and commonly owned, attorneys challenging bans like California's are doubling down. They're walking into court and saying, if the highest court in the land recognizes these rifles as lawful and common, how can any state claim otherwise? It's a devastating legal strategy, a constitutional battering ram. And it's starting to knock down long-standing gun bans, not just in California, but potentially across every state with similar laws. This isn't theoretical anymore. The fight is already underway, and the legal foundations of state-level bans are cracking. Chapter 5. The Opposition's Meltdown. As this legal wave spreads, the reaction from anti-gun judges and politicians has gone from resistance to full-blown meltdown. During oral arguments in Miller versus Bonta, Ninth Circuit judges displayed shocking levels of confusion. One judge repeatedly referred to the AR-15 as a machine gun, despite being corrected multiple times. Another called it an A-15, unable to even pronounce the rifle he's supposed to be ruling on. Worse, some judges floated the argument that constitutional rights might vary by state, suggesting that a rifle protected in Texas could be banned in California. That's not just bad law, it's a direct contradiction of how the Constitution works. Imagine saying your First Amendment free speech rights change depending on your ZIP code. It's absurd, and yet that's the level of logic being used to defend these bans. These reactions aren't just misinformed, they're desperate. They reveal a judicial class scrambling to hold on to laws that are now legally indefensible, exposed by the Supreme Court's clear declaration that AR-15s are common, lawful, and protected. The ground is shifting, and those clinging to old narratives are running out of room. Chapter 6. Nationwide Impact, not just California. This fight isn't confined to California. Right now, 10 states and Washington, D.C. have their versions of assault weapon bans, using similar language to restrict popular rifles based largely on appearance, features like pistol grips, adjustable stocks, or flash suppressors. But the numbers tell a different story. In Illinois, a sweeping ban passed in 2023 affects over 2.4 million lawful gun owners. In New York, compliance with the SAFE Act is dismal. Less than 15% of affected firearms have been registered. In Connecticut, out of an estimated 372,000 banned rifles, only about 50,000 were ever registered during the required period. What we're seeing is a massive disconnect between restrictive gun laws and actual citizen compliance. And now, armed with the Supreme Court's ruling, federal courts are starting to take notice. Judges can't ignore the facts anymore. These rifles aren't unusual. They aren't fringe. They're mainstream and constitutionally protected. The tide is turning, and the legal system is beginning to reflect that reality. Chapter 7. What happens next? So, where do we go from here? Simple. Expect a wave of new legal challenges. Lawsuits are already being filed or revived in states like Illinois, New York, Maryland, and New Jersey, all using the Supreme Court's 9-0 ruling as a constitutional weapon. And these aren't fringe efforts. They're backed by major legal organizations, top Second Amendment attorneys, and a growing list of federal judges who now have clear direction from the highest court in the land. This ruling didn't just shield gun manufacturers, it sent a loud and clear message. AR-15 are in common use, they are legal, and they are protected by the Constitution. The idea that a state can override that because of political pressure or emotional optics? That era is ending. Because in the United States of America, your constitutional rights don't stop at the border of your state. This is the fight of our generation. This ruling is more than just a legal win. It's a major step toward restoring the Second Amendment as it was intended. It confirms what millions already know. Rifles like the AR-15 are lawful, common, and protected. The line between freedom and control. If you stand for your rights, now is the time to act. Subscribe to the channel, share this video, and drop a comment below. Is this the end of assault weapon bans or just the beginning of something bigger? Either way, we'll be right here, covering